to 2007, if the government did not intervene, that claim gets dismissed. So you should, if you're defense, you should really be aware of that. But today they read the same. As I said, this process can be very lengthy, average about 2 years. I know I'm going to get a lot of questions about that from various government people about how long it takes them. And that can go faster or it can go slower. Again, extensions are granted routinely. When the government decides whether it's going to intervene or not, the court, generally at that time, they're asking the court to lift the seal. Generally. Sometimes that happens at a later date. Sometimes prior to the government making the decision to intervene, they will ask the court to partially lift the seal. And that's done to where the defendant can then look at the petition and determine if it wants to settle. It's not a public. It's still not made public. It's still not on PACER. So if you're a publicly traded company, you don't need to make that information known to your investors. But it is partially lifting the seal, so you can see it as a defendant, and you can determine whether you want to settle. If not, then when the court lifts the seal, normal service on the defendant. They have normal time frames in which to serve. And I'm going to take a question right now that was just handed to me. It says, how important is the character of the relator to the government's decision to intervene? I'm going to go out on a limb and tell you, I don't know if it mattered to me, at least not in my initial decision, because I always looked at it whether it was true or not. Some relators, they've lost their job. They will never be able to go back into this area of work again. Some of them, these cases go on so long, and it becomes the relator's focus that they're not always the best witnesses as time goes on. And so, and maybe they're just not comfortable in this area. You need to look at whether what they're bringing you is true. I mean, it certainly makes a decision, I think, their character later, if you're looking at putting them on a witness stand, whether they make a good witness, it certainly makes a decision later on. But I think my initial decision, I would have to say, it probably doesn't matter, their character. Now, having said that, if they're also in, the statute provides under both, and you need to look at this under both the False Claims Act and the Texas statute, it has certain caveats if you also participated in the fraud. So certainly if the relator is part of the fraud, that has a huge impact. But in terms of just whether they're not great witnesses, whether or not they didn't work very long. I think I had a relator that worked for a company for, I think, 6 weeks. Where that causes problems, actually, is they may not know the inner workings of this company well enough to know if what they're looking at is fraud or not. It may be perfectly valid and legitimate that a third-party company is billing a certain way or providing certain information, and the relator just doesn't know that. But, it still didn't change the fact that whether or not what they gave me was true information or not. So I think that's a valid question. And I just think it's something that you have to know as a litigator when that becomes very important to you, or at the